All right, guys, let's get into this story. This is a really crazy story, and I can't even believe the outcome. All right, you guys, this actually came to a surprise. I actually followed Doug Benefield, daughter, Eva Benefield, on all social media platforms. She has an amazing t-shirt line. I will link her website in the description box below. I love Eva. I think as just a young adult who's lost two parents, I couldn't do what she's doing, man. I couldn't. There's no way. And then like to have to deal with the sentencing, but I'm glad that they finally followed through, because I think a few weeks ago she was on TikTok and she was like, "Oh, I was, they were on her and her friends were on her way to drive down for the sentencing, and then like Ashley's attorney filed like a short notice motion to like have it stalled, or I don't know, something." And but this time it actually went through. I did listen to I did listen to Eva's statement, and a little bit of Tommy, which was Doug Benefield's brother's, his impact statement. I would play them, but the defense continually objects to everything. I've never seen this happen in victim impact statements at all, ever, honestly. And I've been watching trials since Casey Anthony. If you're new here, Casey Anthony was the thing that activated my senses to trials and crime and true crime and justice and all of that. I've never seen that happen before, but it's really irritating. I'll leave the link to this video. You can watch it in full, just like I'm going to do with all the other ones, or like I try to do with all my other ones. And there's tabs. I don't know if she speaks, but I know that her attorney is a lot like James Owens, Sarah Boone's attorney, and just has to repeat the same thing, and they kind of have the same thing kind of going on. But I don't know the sentence yet. So let's see. There's closing arguments. And if you don't know anything about the Black Swan murder trial, I have a video. I will link it in the description. I think that was before I started doing these kind of videos, so I don't know how great it is. Probably not great at all. But Ashley Benefield claimed self-defense in shooting her husband, Doug Benefield. But she was found guilty. So let's see. All right, let's get into sentencing. I feel like Judge White is she wearing regular clothes. She's not out on bond. She was during the trial. And then they cuffed her and all of that, gosh, 3 months ago. And she's been in jail. But I feel like Judge White is going to be one of the judges that actually has some of his own. You guys hear my tortoise right now? If you hear that scraping, she's scraping against her little bedroom wall. I feel like he's the type of judge who's going to have like some things to say. And I like that. I like that in judges. I love Judge Kranick, but sometimes I just want to be like, I want to hear, like what they really think. But let's get into it. Ooh. She looked really evil there.
Sentence cannot be imposed. All right, so the first thing we need to do is talk about the bases that have been argued for downward departure. And I think today it's an absolute tragedy that we're even here today. And I often, in these situations, sit back and wonder, how did we get here? How did life bring us to this point, not only here in court, but between the Benefields? I think both sides have acknowledged, because both the defense, Mr. Taylor, and the state talked about lenses and perspectives. And I think this is a good example of exactly that, where whatever lens you view this case from can really affect how you view the players, the results, the participants, and the outcome. So we've got the score sheet to start from. The issue is whether a downward departure has been sufficiently, the burden of proving that has been sufficiently met, and then whether the court would grant a downward departure. So the bases are, and I'm going to just take them in alphabetical order from the statute, 921.0026 subsection 2. The first one is D. The defendant requires specialized treatment for a mental disorder that is unrelated to substance abuse or addiction, or for a physical disability, and the defendant is amenable to treatment. In that particular one, there was the testimony by Dr. Russell that she has diagnosed the defendant with PTSD. It's a complex trauma. She explained the genesis of it and how she reached that conclusion. But importantly, what needs to flow from that is a description of what that specialized treatment is, what sort of treatment is important or would be necessary to treat that PTSD, inpatient, outpatient, what kind of mental health therapies, and so forth. So based upon the competent and substantial evidence that has been presented, I do not find that D has been proven by preponderance of the evidence, all the elements of D. F, the victim was an initiator, willing participant, aggressor, or provoker of the incident. The reason I asked that question, and I was looking around, is I had a case, and I thought I put it in my packet for today, but I'm not seeing it. There was actually a decision in the Florida Law Weekly within the past couple of months, it hasn't been too long ago, where that very issue was discussed. And the DCA in that case actually came down and said, when it talks about the incident, the evidence must support that the victim was an initiator, willing participant, aggressor, or provoker of the incident. And specifically said the court should not consider all of the pre-existing or attendant circumstances and just look at that incident. I think both sides took a great amount of time throughout this case to talk about incidents and events and happenings that occurred before September 27th of 2020. Do I have the date right? September 27th of 2020? But I think the case law talks about that particular day or that particular event. And it doesn't need to be, for this downward departure basis, the law is very clear. The defense doesn't have to prove it by clear and convincing evidence beyond a reasonable doubt. They don't have to prove or provide evidence that is beyond a reasonable doubt. So the question is there competent and substantial evidence that in the incident itself, the victim was an initiator, willing participant, aggressor, or provoker of the incident? And quite frankly, the evidence, the preponderance of the evidence has established that Ms. Benefield's testimony is sufficient in and of itself, and I understand the state is arguing that to discount her credibility, but is there evidence in the record that proves by a preponderance that Doug Benefield was an initiator, willing participant, aggressor, or provoker of the incident? And there is. That was the entire basis of the self-defense argument. So I do find that the requirements of F have been met. G, the defendant acted under extreme duress or under the domination of another person. This is why I was asking about the case law, because I have not seen this particular statutory basis applied in this particular factual scenario where it's argued that the defendant acted under the extreme duress of the victim as a self-defense matter. But just because I haven't seen the case law doesn't mean that it doesn't exist and it can't be argued for those or that purpose. So for the purposes of today, using a similar analysis as I did under F, but also considering the past relationship between the parties, I think there has been competent, substantial evidence to establish by a preponderance that the defendant acted under extreme duress. The domination of another person, I just don't think fits. So to the extent that that particular downward departure basis requires that the duress comes from a conspirator, a co-conspirator, a confederate, or a principal, I could be wrong, but I think it applies, and I'm applying it here. Or I think it's been proven. And then J was the offense was committed in an unsophisticated manner and was an isolated incident for which the defendant has shown remorse. The case that I talked about a few minutes ago regarding victim was an initiator, willing participant, aggressor, or provoker of the incident, J has similar language. The offense was committed in an unsophisticated manner. So I understand the state's argument saying, hey, this was a whole series of events and was very sophisticated in its planning and execution. At the end of the day, the statute itself says the offense was committed in an unsophisticated manner, isolated incident for which the defendant has shown remorse. So if I look at just the incident itself, there's nothing sophisticated necessarily about self-defense and using self-defense. Isolated incident, the defense has pointed out, and the score sheet shows there are no prior acts of violence, there's no prior convictions. The case law requires, though, that all three elements of this be established. The final one is the defendant has shown remorse. Obviously, she's exercised a very, very fundamental constitutional right by not making a statement today. But I can also, I believe, consider the testimony that was provided during the trial. And remorse is not necessarily, and doesn't have to be, I'm sorry I did this. Because someone is perfectly entitled to maintain their innocence even in light of a verdict of guilty by a jury. So I find that during the trial itself that Ms. Benefield did demonstrate remorse for this entire incident happening and the culmination and the resulting death of Mr. Benefield. So I do find that J has been established. The non-statutory bases, there were none explicitly argued, but I'm going to make a ruling on the individual and culmination of errors for appellate purposes. Again, I'm not aware of any case law that establishes that. To the extent that there's an argument to be made that, and when I say individual errors, I'm talking about fundamental error, right? Because that could just be one thing and fundamentally vitiates the fairness of the entire trial. So individual or cumulative errors being the bases of a downward departure, I'm going to go ahead and make the finding that those are not, errors by the trial court are not bases for a downward departure, non-statutory bases. I may be wrong. We'll find out. The second part of the analysis is whether the court is going to exercise its discretion to depart. And that's where you really take into consideration those factors in determining, in light of all of the facts and evidence that have been presented, if this is a case that the court believes a downward departure should be granted. And as I said, I understand completely that two sides of this room are viewing this same case through very different lenses. As I consider all of the evidence that I talked about earlier that I reviewed in preparing for today, the jury's verdict, which they did not find Ms. Benefield guilty of the charged offense. It was a lesser included offense that did not include depraved mind. It included doing an act which resulted in the death of another person. I consider the score sheet and what Florida statute or chapter 921 discusses regarding the aim of sentencing, that being the primary purpose of sentencing is to punish, the secondary purpose is to rehabilitate. The PSI, which has been reviewed and considered, and I understand throughout the arguments that the defense has raised their disagreements. For what it's worth, the PSI in the factual part really just recreates or retypes the complaint affidavit. I don't really put a lot of weight on that. I don't need that because I presided over the entire trial. So I don't put a lot of weight on the factual recitation that was in the PSI. And as we all know, the PSI is not controlling on the court. The probation officer who does the report makes a recommendation, but unlike in juvenile court, where the Department of Juvenile Justice's recommendation is somewhat binding on the court, the DOC recommendation is not, but I did review that. And of course, as I said, I reviewed the defendant's sentencing memorandum, all of the various attachments, and listened to the statements that were made today from Dr. Russell, as well as David, Wes, Tommy, and Eva Benefield. And all I can say is thank you to everyone who took the time to write a letter and share your experiences. A number of them talked about growing up with Ms. Benefield, their interactions with her as they've grown up and growing into adulthood. Thank you for the statements regarding your relationships with Douglas Benefield and how his loss has impacted each of you. So when I look at the bases for the downward departure and I consider all of the facts and evidence that have been presented to me, my ultimate conclusion, Ms. Benefield, is that this is not a downward departure case. So with that said, the sentence of the court will be as follows. I'm going to sentence you to 20 years in Florida State Prison. That's to be followed by 10 years of probation. Upon your release, and the Florida State Prison was, of course, with all credit for time served, you must initially report to the Bradenton Department of Corrections. We'll be able to provide you a map of where that is. Cost of supervision will be a condition of supervision. Based upon the testimony of Dr. Russell today regarding you suffering from and being diagnosed with PTSD, the court is going to order as a condition of your probation that you obtain a mental health evaluation at your expense within 60 days of beginning your probation. You're to complete any recommended treatment, including residential treatment and aftercare if it's recommended, on the first attempt at your expense. You're to provide proof to your probation officer regarding the evaluation, participation in, and completion of that treatment. If it's necessary for your probation officer, you'll sign any waivers or releases that are necessary for them to get the information that they need or speak with your evaluators and treaters. I am going to order the forfeiture of the firearm in this matter, that being the Springfield .45, and I'm ordering that you have given up all rights, title, and interest to the same. I haven't heard anything about restitution at this point. I am going to order restitution. I'll reserve jurisdiction to determine the amount of restitution, the payee or payees, the payment schedule, if any, and other terms and conditions of restitution. I'm also going to reserve jurisdiction on the restitution to determine whether or not to waive or reduce the monthly cost of supervision and/or the fees and surcharges that are associated. I'm going to impose the following monetary obligations: the felony adjudication of guilt court costs, $100 cost of prosecution.
200.
Do you have an affidavit?
I don't have it with me.
I can look.
If you need one, we can get one.
It's required by Florida law.
Just, there's,
If you want to
3,000
continue on,
page.
we'll try and find it.
All right. If an affidavit is for cost of investigation is presented, I'll order $200 to the Marietta County Sheriff's Office. For now, I'm going to make all the legal financial obligations a condition of probation. All right, State, now that you've seen where I'm at with the sentencing, was there anything that you want to do, any further arguments, anything else you want me to consider?
Judge, my only concern would be the mental health evaluation. I would prefer that it not be with Barbara Russell when she's on probation and has to do the mental evaluation.
You don't want what?
You have ordered that the defendant do a mental health evaluation when she gets out on
Correct.
probation, and I would request that it be someone other than any of the doctors that were involved in this case. So not Barbara Russell or Dr. Quintal or Dr. Broder. Those-
Okay. I'm not going to order that. I'll let you pick your mental health professional that you want to see and consult with. Sir, now that I've told you where I'm at, was there anything that I need to explain or clarify?
No, sir. If you would, how long is the period of probation?
It was 10 years. Okay, Ms. Benefield, you have 30 days to appeal the judgment and sentence of, oh, yes, sir.
Make one statement for the record. I object for the record and argue it's an abuse of discretion based on the undisputed facts not to grant a downward departure.
Oh, yes, sir, absolutely. I think that's generally preserved no matter what, but
I do too, but.
I appreciate your belt.
But the appellate courts like to find not preservation, so I'm overly careful.
I understood. Belt and suspenders, no problem at all. Yes, sir. So, objection to the abuse of discretion for not granting the downward departure. Noted. All right, Ms. Benefield, you have 30 days to appeal the judgment and sentence of the court. If you can't afford to hire a lawyer, one will be appointed to represent you. Go ahead.
Sorry, I'll just have one thing
Is it regarding appeal?
regarding,
Appeal?
no.
Oh, well, go ahead then.
I was going to ask the court if the court would make arrangements to ensure that Ms. Benefield remains in Manatee County for at least 14 days, if not 30, so that we can tie up all the loose ends in preparation for the appeal.
Okay. I don't know how much pull I have over that. DOC comes gets people when they come get them.
Can I suggest that Your Honor set this for a report in perhaps 30 days?
All right, why don't you send me an order directing the sheriff to hold her pending any final hearings or matters? And I'll,
Judge, the most specific thing, we're going to be filing a motion for bond pending appeal, so that's why we're.
keep her there for that.
Yes, so to avoid the necessity of her going back and forth.
Absolutely. So do me a favor, contact Kelly, my JA, get that set. I didn't see it's been filed yet, but get it filed.
It has not, but I will file it tomorrow.
All right, get it filed. Talk with Kelly about getting a hearing date, and then I'll sign an order to hold her until after that date. Absolutely.
Thank you, Judge.
Thanks.
Of course. Okay, for the appellate purposes, what I was going to say is, ma'am, speak with your attorney. You can hire someone if you want, a private attorney for that. If ultimately you are going to seek the services of the public defender, I'll just need a financial affidavit and a motion to appoint. And then once Mr. Taylor completes all of his obligations as trial counsel, we'll get a local PD appointed and then the 10th Circuit PD. All right, ma'am. Thank you very much.
Okay. Oh, dang. About to rip her ass out. Oof. Wow. All right, so she's gonna get fingerprinted. While she does that, she got a 20-year sentence, followed by 10 years of probation. I was just looking up her age because I know that when she met Doug, she was 24, and like online I'm finding articles so she's 30. I could just look up her birthday, right? I'm too lazy for that. But there's another one that's saying she's 33. So if we do the math, she's going to be out around the age of between 52, 53 years old. There's Eva. Oh man. I know that she's so happy. So, and then she has 10 years of probation. Very odd. Not odd. I mean, this is just something I haven't seen before. Which is completely fine. This judge definitely, you could tell, did not agree with the verdict from the jury. Maybe they should have done a bench trial, who knows. But yeah. He I could tell that he definitely in the beginning of this case, I really felt like he had enough of the defense. But I'll be honest with you guys. I said this in the I think one of the other videos I made of this case, with her verdict, I think it was. The state, the two women that, I mean, that was representing the state in this, I just feel like they weren't on top of their shit. Like him asking for a certain document and then like them knowing by law they need to have it, and they're just like, and then like you can hear everything they're saying. I swear I heard like, oh, he's gonna be a smart ass or something. Hot mic moment. All right, guys, this is the last video for today. Make sure you like, if you do like this video, please press the like button. It helps me out tremendously, and I really appreciate it. Share, subscribe if you like this content, and let me know what you think about the sentencing. I always love feedback, guys. So that's all for this one.
And if you enjoyed this video, please like, subscribe, and share with some friends.